Chapter 18. Purdy's Purview. Fortunately for Nick Power, the press forgave him everything. Once the detective had sidestepped his public relations bungle, one very real problem remained: Peter Wheeler had yet to be charged with any crime. The prisoner was left to languish in the Digby jail under a suffocating cloud of suspicion and could do nothing but await what the fates had in store for him. The next link in the legal chain was to formally indict Peter for Annie's murder. The findings of the coroner's inquest had no judicial sway but had primed the public for a specific outcome. It was never Dr. Lovett's decision to make, but once made, there was little question that Wheeler must pass through the magisterial machinery if he had any hope of clearing his name. The burden of proof now rested with the region's chief prosecutor, Mr. Albert J. Kopp. Kopp was the county's maverick, a mere 36 years old. He possessed a keen legal mind and formidable reputation that belied his relative youth. Wheeler represented Kopp's first shot at a murder conviction, the sort of case that helped cement an ambitious man's position in the world. Protocol dictated that Kopp impanel a grand jury of Wheeler's peers, 12 local men of good standing and character. Once seated, the jurors would hear only from Kopp, who would present the case without any input from the accused or defense counsel. The prisoner and his lawyer were not even permitted to attend the hearing. If the panel felt there were adequate grounds to proceed to trial, they would vote a true bill leading to a formal indictment. Given the severity of the crime, the case would then be remanded to the Provincial Superior Court to be heard at the next special session. Rather than send Wheeler to Halifax, however, an experienced Supreme Court justice would be dispatched to the county seat to oversee the proceedings. There was, of course, another legal option and, this being the case of Peter Wheeler, the less traveled path proved the preferred course. The media spotlight burned too bright and there was political hay to be made from its heat. A local county magistrate, the Honorable Wallace A. Purdy, took it upon himself to hold his own examination of the case. Purdy's inquiry was not intended to quash Kopp's authority, but it was unquestionably meant to commandeer the headlines. Judicial intent notwithstanding, Purdy's tribunal, technically known as a police magistrate's examination, featured many of the usual aspects of a trial. It was presided over by a judge, in this case, the self-appointed Wallace A. Purdy, and the accused was present and represented by defense counsel, who could cross-examine the witnesses. There were some restrictions. For example, the defense team could not call any witnesses to rebut testimony or refute evidence, nor could the accused testify on his own behalf. As the examination was procedurally at odds with a grand jury, the end result also differed. Purdy's hearing would not culminate with the indictment of Wheeler. Despite the facade of a trial, it was, in fact, little more than a rehash of Lovett's coroner inquest, right down to the exact same witness list. The only net benefit to the charade was that, if Purdy so ruled, the Crown could continue to hold Wheeler pending formal charges. There was, of course, the slimmest chance that Purdy might find the case wanting and release Peter, but the likelihood of such an outcome was negligible. Still, it was opportunity for the newly appointed defense team to meet their client and hear firsthand the evidence against him. Purdy's Vanity Fair found an unlikely home, the Bear River Exhibition Building, an agricultural behemoth normally reserved for livestock that retained the telltale lingering stench of manure. Unlike Lovett's inquest, which was held in the well-situated confines of the Oakdean Academy, the exhibition complex was outside the city limits and lacked all of the Academy's comforts. Though reporters and spectators alike carped about the change of venue, no one seemed deterred by the inconvenience. Horse teams drove legions of the curious from across the county, and despite the venue's cavernous dimensions, many were turned away due to overcrowding. Whatever its dubious legal value, Purdy's hearing was undoubtedly the social event of the season. The building was not up to the task. The infrastructure was strained beyond capacity as more than 1,000 people crammed into every available nook and cranny. The floor had to be shored up in several locations to prevent a potential collapse. As the construction delays dragged on, the air grew blue with tobacco smoke. The open flames and carelessly discarded ash practically begged for an ill-timed disaster. As for lavatories and other crucial amenities, spectators were left to their own devices. The humble surroundings did little to dampen Justice Purdy's mood. Knowing that the eyes of the province were upon him, Purdy assembled a stellar cast of supporting characters. Albert Kopp was relegated to playing second fiddle as the Crown Prosecutor, while F.R. Miller completed the roster as the Clerk of the Crown Prosecutor, while F.R. Miller completed the roster as the Clerk of the Court. Such distinguished dramatis personae deserved a proper stage. In defiance of the building's distinct barnyard aroma, the judge ordered a team of workmen to craft a bench worthy of the Supreme Court, behind which the Honorable Justice Purdy took his rightful, and noticeably elevated, place. Defending Peter Wheeler was none other than Henry Dwight Ruggles, a barrister with his own firm in Annapolis Royal, Mills and Ruggles. Ruggles, who went by both Dwight and Henry, was something of a pioneer in commercial jurisprudence. His notoriety stemmed from his revolutionary practice of advertising his services in the Annapolis Spectator. Dwight's advert, which prominently featured his 2-digit telephone number, sat in pride of place astride the Spectator's masthead. He paid handsomely for such prime media real estate, and his aggressive marketing strategy paid off. Ruggles, a slightly more refined precursor to the ambulance chasers and personal injury solicitors assaulting modern society with their late-night infomercials and shock tactic billboards, may have raised the ire and eyebrows of his staid colleagues, but those in need of a lawyer knew exactly which number to call. The star of the coming spectacle was the accused, although Purdy was no doubt loath to admit it. Negotiating a gauntlet of press and choleric citizenry, Peter Wheeler was transported to the makeshift court in chains, flanked as always by the imposing figure of Detective Power. Actually, that is not entirely true. Power made a show of accompanying Wheeler, yet history has it on good authority that it was little more than a Victorian-era photo op. When no one was looking, Wheeler was transported and guarded by the Harris brothers, C.M. Harris, who ferried Wheeler to and from the jail, Rupert Harris, responsible for supervising or boarding the prisoner between sessions, and brother Manning Harris, who attended the prisoner as he sat before Judge Purdy. For their sins, the Harrises received the princely sum of $45.74, although the distribution of wages amongst them was far from equitable. C.M., covering the most miles, pocketed $23, while Rupert took home only $7.99, leaving Manning $14.75. For his well-publicized but minimal efforts, Power received nothing but his regular salary, the public's unwavering devotion, and constant media coverage. Constant was the operative word. Reckoning that their normal publication schedule was insufficient to meet the insatiable appetite for Purdy's forum, the Annapolis Spectator elected to print special editions or extras, single-sheet summaries of each day's events. Priced to move at 1 cent, the Spectator deferred production costs by securing a sponsor. The extras were brought to the masses by the good folks at Cherokee Vermifuge, which, if their slogan can be trusted, kills worms every time. The carnival began with a resounding bang. Judge Purdy, sporting his best judicial regalia, gavelled his examination to order on the morning of February 7, 1896. As befitted such piffle, early media speculation did not focus on the evidence or precedent. Rather, the press was at Twitter with a matter of stature, specifically the colossal stature of the judge and the chief detective. Newshounds eager to paint the most vivid picture dedicated an inordinate number of column inches to ruminating on the height of the key players and debating who cut the more imposing presence in the courtroom. Judge Purdy was said to be an unusually tall man, with a large frame. The magistrate's hearty reach, however, paled in comparison to that of the well-cast Nicholas Power, who stood 6 feet 3 inches in his stocking feet. The two men, models of splendid Victorian brio, were seated side by each on the swiftly constructed dais that left them towering, figuratively and metaphorically, over the crowd below. The fuss paid to so trivial a matter seemed an apt analogy for the proceedings itself. With such vital issues addressed, the spotlight reluctantly shifted to the matter at hand. Wheeler was escorted into the venue, bent and submissive, yet shackled as though he were a clear and present danger to all who beheld him. The true absurdity of the hearing was revealed in its first exchange. Although Wheeler stood indicted of no crime, Purdy asked the accused how he pleaded. Caught off guard, a bewildered Ruggles spoke on Wheeler's behalf, giving the only reasonable answer, not guilty. The first witness to take the stand was the coroner Dr. Lewis Lovett. Despite his inexperience, the physician was a paragon of scrupulous exactitude. He carried with him his notes from the inquest, 29 foolscap pages crammed with tiny meticulous printing in Lovett's distinct hand. After summarizing the inquest's findings and admitting the notes into evidence, Kopp arrested the witness and Purdy signaled the defense to begin their cross. Unlike his worthy opponent, the defense counsel was not blessed with a formidable reputation. The only way Ruggles saw his name in the papers was to pay for it. This bootless legal exercise was Ruggles's debutante ball, a coming-out party for a lawyer desperate to stake a claim among the province's affluent elite. At long last, Ruggles's moment to shine had arrived and, if his efforts helped his client, all the better. Approaching the bench as a cat stalks a mouse, Dwight Ruggles set his sights on the novice coroner. If Purdy could play silly legal games, so could Ruggles. In a hushed yet belligerent tone, Ruggles objected to the admission of the inquest notes into evidence. He stated that the inquest related to a separate matter, namely the determination of the cause and manner of Annie Kempton's death. With a barely concealed smirk, Ruggles reminded the court that the case before them was the guilt or innocence of Peter Wheeler. As such, Ruggles argued, the inquest had no bearing on the issue at hand. It was an audacious, almost foolhardy, opening salvo, but Dwight was just getting warmed up. The defense then unleashed a litany of objections, including a motion to exclude the inquest testimony in its entirety. The move surprised Kopp and Purdy, who demanded to know on what grounds. Ruggles chuckled and paused. "These grounds," the advocate replied, pointing to the floor. As questioning murmurs rippled through the Cowshed Coombe courthouse, Ruggles turned and played to the crowd. Purdy and his cobbled throne sat in Digby County, Ruggles reminded his rapt audience, yet the testimony had been given in another county, Annapolis. With all due respect, he gleefully told the court, the esteemed justice had no authority outside his county seat and no jurisdiction whatsoever over events in Annapolis County. Before Purdy could rule, a bombastic Ruggles stormed ahead. He also wanted all witness statements taken in Digby County excluded, arguing such evidence was introduced to absent the accused or his counsel. His client, Ruggles thundered, had been denied his right to confront his accusers. Accordingly, all evidence from the inquest should be stricken from the record. The judge now had his choice of reasons to exclude the inquest materials, the county issue or the violation of Wheeler's civil rights. It was a masterfully antagonistic performance, though one doomed to fail. Unswayed by Ruggles's theatrics, Purdy elected to overrule the objection, giving a minor victory to the prosecution. Lovett's proclamation of Wheeler's guilt would stand. The defense team could no more strike the coroner's overreaching verdict from the court record than it could erase it from every media account in the land. That genie was out of the bottle and no amount of legal showboating could put it back. Purdy's ruling left Ruggles hobbled but re-energized. There was still some ground to be gained as the witness had not yet been excused. Lovett had sat patiently during the defense pyrotechnics, waiting to be dismissed, but Ruggles had no intention of letting the good doctor off so easily. For the first time, all would hear the uncensored version of what the coroner saw the day Annie died. At Ruggles's urging, Lovett recounted the morning the body was discovered. The coroner arrived at the Kempton home just after 9 o'clock. The corpse lay between the stove and the window, an environmental confluence that wreaked havoc on Annie's body temperature. Lovett understood that cadavers cooled after death, although he admitted having no prior experience in using body temperature to estimate the time of death. The doctor told the court he had tested the body's temperature by placing his hands on her skin, a far from exacting method. In the end, after being grilled relentlessly by Ruggles, Lovett conceded he had no way of knowing how long Annie had been dead. Kopp rose to redirect. He asked Lovett how long it would normally take for a body to cool after death. With nothing practical to draw upon, Lovett's answer was vague. It could take 12, 24, or 48 hours, Lovett posited. He simply could not say for certain. Although the answers were frustratingly obtuse, the exchange clarified a salient point. The question of when Annie died was quickly becoming both the linchpin and the bane of the case. It was a subject each side would return to time and again throughout the investigation. With nothing more to be gleaned from the coroner, Dr. Lovett was dismissed. He was quickly followed by the now familiar parade of witnesses who had taken the stand during the inquest. Each of the 24 attestants reiterated their prior testimony almost word for word, with one key exception, Hardy Benson who, as we shall soon see, revised his statement in lethal ways. The lone piece of physical evidence introduced was the short length of firewood allegedly used to knock Annie unconscious. Although weighted with sinister connotations, the actual wood as a cudgel was rather unimpressive. As Mr. Payne succinctly stated, it was not a formidable-looking weapon. Although it was an anaphora of Lovett's inquest 1 week prior, Purdy's folly was still the biggest game in town. And, as with all good serials, soap operas, and dime store novellas, the secret to success lay in the cliffhanger, the tantalizing glimpse of the next heart-pounding installment. While such prognostication often proved difficult in legal endeavors, somehow the editor of the Annapolis Spectator pulled it off. The tagline of each special edition announced that perhaps the most important evidence yet will be given today, baiting their loyal audience to tune in next time. If such lures were not enough, the editor implored his readers to be sure and get a copy of the next Spectator Extra, only 1 cent. You get what you pay for, the editor's 2 cents worth, and a bargain at half the price.